also removements that you have in a standalone case. So although you are, in a sense, simplifying some of the calculations, you're having many more calculations to do. So there's both pluses and minuses here.
I've got a few more questions, and I'd be happy to do another round at the pleasure of my colleagues. Just to pick up on one of the issues I was exploring earlier, if we were to just work with me here, if we hypothesize that the board comes up with what each or most members on this panel would view as a very thoughtful, this is hypothetical, of course, balanced and fair rule here. Should we then expect over time, as hourly fees do go up, I presume, like they do in most other business models with inflation and cost of living, that in a few years or over some period of time, that very good, thoughtful, fair balance may not look quite so good to folks paying the actual hourly bills, and we would then be asked perhaps to come back and revisit the question. Should we be concerned with that? Is that a real reality? And I'd welcome any comment on that or related issue.
I believe the board, in its proposal, had talked about the possibility of indexing certain of the costs. I think that makes some sense. There is a whole series of things in the law that not just obviously the transportation law that the board is under, but other transportation statutes that have, in a sense, gone out of date as time has gone by. And I think an indexing process for some of those would make a fair amount of sense and reduce the need for the board to revisit what we certainly hope it will be a fair and expedited process at the end of this proceeding.
I think it would be helpful generally if in a decision that the board issues, it could indicate its willingness to be receptive to indications of change or abuses of the process as you go along. And I think that this is just one of the areas that perhaps needs to be revisited over time, or may have to be revisited over time with the benefit of experience. There may well be others of a substantive nature.
I'd like to give each of the panelists a chance to, some have spoken very directly on this point, some somewhat less directly on the question of thresholds. I'd like to give each panelist an opportunity to and maybe to help move the questioning along, if I could. If this is a big if, I realize, if we assume that the board were to settle on a three option approach, full SAC, simplified, or something like a simplified SAC, and then a more benchmark type, even simpler approach. If we were to proceed with a three option model, and to take it further, to pick up on Mr. Mulvey's comment, Commissioner Mulvey's comment, if we were to give shippers an opportunity to opt into the value level of any of those models for purposes of the case, what should the threshold be? I've heard some different numbers, but I haven't heard numbers from everyone. Clearly, this panel, I've heard that 200,000 in your collective opinions is not the right starting number, but give me a better one, if I could. Just if I could just start maybe my left to right, just. And if you prefer not, if you don't have that number, that's fine. I just would want to get the benefit of your thoughts while I've got you here.
We're talking a threshold number now.
Yes.
In our testimony, we mentioned 13.5 and I believe 10.5 million, and let's stick with those numbers.
Anything on the third lower end?
Well, I mean, in theory, you could actually, well, you're not going to have a case, I think that's brought on one or two carloads, but I know like using our immediate situation, most of our origin destination pairs, you're only looking at between maybe $750,000 and $1 million in revenue, and that's just on an OD pair. And most complaints are probably going to be directed at one origin destination pair. So, perhaps say $500,000.
Thank you. Mr. Kraftberg?
I guess I'd go back to one of the other comments that I made earlier in my testimony when I talked about the number of shipments on an annualized basis that really would apply. And I guess based on the proposed thresholds at this point in time, looking at 2 carloads a month on an individual OD pair is quite low. And so when you calculate that over a 5-year time period, that's why we said that we really felt like $200,000 was really unrealistically low. And as we had stated, that anything basically below the $10.5 million threshold, we'd really be looking for that to apply to the 3 benchmark standard. So I think most shippers would once again need something that says I can aggregate those shipments, or I can submit a case that may have multiple origin destination pairs, which in themselves have only a couple shipments per month. But I've got enough latitude there to bring a little bit larger case if I've got 3 or 4 OD pairs that I really feel or that the company feels needs to be changed.
I think our statements were focusing primarily as it relates to ag commodities and ag products, focusing primarily on the 3 benchmark. Our statements were obviously clear that we thought that $200,000 was too low. However, we have not formulated a limit that we would like to care to discuss at this point. We don't have that number as of yet.
Okay. And it's certainly your option, Mr. Mack, but I will just point out for everyone's benefit, the record will be open until February 26th, and we certainly would invite you to give us your association's best number. It may be very helpful, and it's just hard for us to, if we don't have the benefit of folks' specific recommendations, it's just tougher for us to make the right call, but I appreciate your position today. Mr. Goldstein?
Well, speaking on behalf of NGFA, we will submit some numbers for you. As part of the aggregate group, we've already suggested some numbers that we think are appropriate that Mr. DeMichael, I think, can reiterate. I think it's important to point out, though, that while these numbers may seem large, we're talking about 5 years' worth of relief. And so when you divide them by 5, they shrink dramatically. And then, of course, if you factor in what the board has said needs to be factored in, which is some sort of a cushion, because you can't expect people to litigate just to recover their costs. So when you get done with that, you get down to a number that we think is manageable.
Those numbers to repeat, basically, I think what Mr. Warfeld talked about was that 3.3 benchmark would be up to 10.5. A simplified SAC would be up to 13.5, and a case that is worth more than 13.5 would be under the full SAC.
Thank you. Mr. Crowley?
I concur with Mr. DeMichael.
Okay. Mr. Powell? All right. Thank you. This may be my last question, but I think it is an important one. There was some testimony about of course, the length of time of pursuing these cases. That's certainly very much in the forefront of our mind, is trying to come up with the right balance here to try to figure out a way to get through these cases expeditiously. I think most, if not all, of the statements I've seen in the record from a variety of parties appreciate the importance of that. Help me improve our work. And I realize this may be more directed to the seasoned litigators on the panel, but I'll invite anyone else to join in. Where, looking at our proposal, where do you see opportunities to cut off some time? And then a related question, I guess, in your experience, in cases with the board, generally speaking, do you see, very often I'm learning as I continue my orientation process here about 6 months into the job, that very often we start off with a very well-intentioned schedule, and then various things happen, not the least of which parties ask for a different schedule. How often in cases is the lengthening of the resolution process beyond the original schedule attributed to parties, railroads, and shippers actually asking for delays, extensions. How often is it because the board is, for whatever reason, just can't get its job done on time? Help me think through how much of the problem is it on my end that I need as a manager to try to get at, and how much is really just maybe the inevitable give and take of the process that the parties have a right to ask for extensions.
Let me take a whack at that in really a couple of ways. First of all, the three benchmark approach as proposed would be, and it's a little unclear exactly what the time period is, but I believe it's about a 270-day schedule. 50 days of that schedule is devoted to the eligibility question. If we could have a realistic and bright line test, you would knock out 50 days out of that 270-day schedule right off the bat. If you could say, a large percentage of shippers would be able to not have to go through a individualized eligibility process. We look at the three benchmark approach, and it seems to be something that could move along fairly well. And we think that even if you go from the 270 to the 220, there are probably by knocking off the 50 days, there is still probably some means of getting that down a little bit further. Now, if you're going to the simplified SAC, I think you were talking about a whole different kettle of fish. The history of SAC cases has tended to be that they start out with everyone's good intentions, including the board's, trying to get them done in X period of time, and they're just expanded. I know the Otter Tail case, for example, that was not atypical. It took a little over, I think, about three and a half years, and there were several rounds of evidence in that case. One of them that was the result of a change in one of the board standards that one of the parties asked to respond to. A second, the board standards changed again, and another party asked to respond to, and the third, the board itself asked the parties to submit. So some of that case was due to some changing standards and the board itself asking for some additional evidence. We think those are the kinds of things actually that are more likely to take place in the simplified process rather than a three benchmark process, where the three benchmark process you've got two of the numbers that the board is going to calculate. The third number is a comp number which you'd think would be able to be done fairly fast.
Doug, I think what you're talking about has some potential, but from my personal point of view, there was some confusion as to the small claims approach. The original approach or suggestion for determining eligibility involved the use of presumptions, and the presumptions could be challenged by presumably either side in every case. It's not clear to me whether the small claims approach, allowing people to choose to fit into one slot or another, also involves presumptions, or whether they are no longer part of the picture. So I think part of the answer to the question, in my mind, lies in the answer to that particular issue. Also, another part of it is whether what you call the aggregation rule, I think of as the aggravation rule, is dropped. And if it is, I think that will also help speed things up.
Let me just add that one way to help out the small shippers is to get rid of the simplified standalone approach altogether. Embrace the three benchmark approach without aggregation, and I think you'll offer a tool that these small shippers will be able to use, and it'll be quick.
Vice Chairman Butler, any additional questions?
No question, just an observation, Mr. Chairman, on the issue of indexes. We haven't had much luck with that in the recent past.
That's right. Commissioner Moldy?
On this issue of whether or not we should drop the simplified SAC. In our directive, it says that we need to develop an alternative to the full SAC process. And that word "full" in the directive was, I think, important. And I don't know the entire legislative history of that, but that, you know, the choice of words would be very, very, and that sort of implied that a less than full SAC, but it's still a SAC process that's tied to the constrained market pricing principles, was also eligible or was supposed to be considered by the board in coming up with an alternative. And of course, we also have the three benchmark. Can you, do you want to respond to the Mr. Crowley or Mr. Goldstein, that part of the directive from Congress?
Well, I think it's clear that Congress did give very serious consideration to selecting the language that it used. And it did that after losing patience with the inability of the ICC to come up with an alternative. It's not an accident, we think, that Congress said that the standard was to be simplified and expedited, and it didn't choose other words. It had plenty of opportunity to do that. And it didn't say, for example, that the board was directed to adopt a simplified full SAC to replace full SAC. And instead, it used the words that it did use. So we don't think that you should read into the statute a directive to adopt a simplified full SAC to replace full SAC.
Mr. Crowley? Okay.
I couldn't have said it any better.
Thank you. Mrs. DeMarco, you've stated that litigation costs have increased from $3.5 million to $4.5 million over the last few years, and in fact, you quoted from $1 million back in 1996 up to $3.5–4 million today, $4 million today. And I suppose we could presume that those costs will continue to rise. And we've talked about indexing these, if we do go for eligibility standards to index them. There are, as Mr. Crowley knows, various indexes developed by the Bureau of Labor Statistics, etc. Are there any for legal fees or for consulting fees that might be applicable for developing an index that are less than 4 digits? I'm sorry.
I think there have been one or two antitrust decisions on that point.
I was just wondering if the BLS actually, but it does do it for a lot of different industries. I mean, you do have cost indices. Of course, you have them for the railroad industry, and a lot of the railroad suppliers have separate indices. And I was just wondering if there was one for railroad or economic consulting.
I'm not aware of one, but I've been looking for one. But I would note that you do have an index that you use every year to classify Class 1 railroads versus Class 2 railroads, et cetera. So.
This idea of developing some sort of factor to multiply the expected value of the cost by to take into account risk. Obviously, someone mentioned that only 2 of the last 7 cases resulted in quote-unquote wins for the shipper. But I believe over all of our SAC cases, it's about 50-50. So you come up with, say, you have a 50-50 chance of winning, so there's your 2. But of course, the amounts that were awarded were not the full amounts that were desired, so therefore, that also needs to be taken into consideration. The number $13.5 million looks as though it's approximately 3 times the estimated cost, and that's what you seem to have chosen. But do you think there's any way of getting a better handle as to what the number ought to be than 2 or 3 or? I mean, some of the numbers I have seen would suggest something like 10 or 20, given the hoped for a win and the amount that was actually got.
Well, I think you're correct, Commissioner Mulvey. That's exactly how we came to this. It was the $4.5 million, and then basically multiplied by a risk factor of 3. And I don't think anyone will say that this is exact science here. That there's obviously some judgment, but exactly the kind of thought process that you just went through. I think what was the one that we went through in coming up with that number. I think we were more affected not so much by cases that may have taken place or that may have been litigated 10 or 12 or 15 years ago, but we're really looking more at current experience, and it's not just the last couple of years, the last 5 or 6 years. So you're talking about at least a decent period of time. And as you mentioned, even the 2 cases that the shippers have won over the last 7, the relief given was not the total relief sought. So that has to be factored into the risk too. So if you take a look at all of that, it appears to us that a risk factor of more than 2 is a fair one.
One question on the ratcheting. Mr. Crowley, you were mentioning that the sample could change from year to year to year, and you gave an example of the confidence interval of the plus or minus 5%. But this example was extremely hypothetical. Do you have any sense of what the size of the actual samples really would be, and whether or not there would be a significant change in the groupings from year to year? I mean, are there that many cases in these groups out there that you could have some substantial changes in the group that's being looked at?
Yes, we've solved these procedures, the 3 benchmark procedures, for a number of folks using the public use waybill file.
Mm-hmm.
And admittedly, we don't have access to the actual data because of the masking factors. But just using the public waybill file and looking at the groups over a 2 or 3 or 4 year period, you see a substantial change in the observations. The size of the group, they can be, you can get it as narrow as 10 or 12 moves, and it's probably as big as 50 or 60 moves, based on, again, the public use waybill.
Okay. Thank you. Just a quick comment and one last question. Thanks for your patience, panel. Just in thinking about the suggested $10.5 million as the proposed bottom number for this new rule, I think we will, as more directed to my colleague, I think if we would accept that, we would definitely have to at least start to not use the term small claims court model, because I'm not sure that would stand the straight face test, but that might not necessarily mean it's a problem. It's just a language issue there. Let me ask, just to quickly get folks on the record, occasionally I hear from stakeholders, visitors, that we should be focused in proceedings such as this on small businesses. And in fact, my colleague, Vice Chairman Parte, addressed the importance of small businesses. Are any of you suggesting today that our focus in this rule should be on the size of the actual shipper? In small business tax law and policy, we often hear things like 50 employees or less, annual income of a certain level or less, and occasionally the government makes certain benefits available to businesses that are small. Of course, as you know, in this proceeding, the focus really has been on the shipment, not on the shipper. But I do want to quickly get folks on the record, and I'll ask others later. Are we on the right track there, or should we be looking at actually the shipper and how much income the shipper makes each year, how many employees the shipper has, or in those type of indicators? Mr. Warfel, just look down.
I guess the short answer would be, in my opinion, no. You could have a complaint on 1 car, you could have a complaint on 1,000 cars, and I don't think you should be restricted in your ability to file a complaint or to have an issue listened to.
I agree. I think the approach that you're taking a look at small shipments versus the size of the shipper is appropriate in this case. You know, recognizing the concerns that Vice Chairman Buttrey has voiced. I think that's been the position all along. That I don't want to speak for Nick, but I guess that's the position that the interested parties have taken, and Knit League has taken as well.
My response to that is there should not be a size limitation on the business side. Not unlike a lot of the grain businesses and grain companies, large or small, they generally act as somewhat of a decentralized entity in that they have assets spread out through the entire United States or North America or wherever it may be. And each of those facilities essentially has to stand on its own. And at least from our company's perspective, is those individual facilities act as small individual business. They have their own P&Ls, Yes, they have support in the backing of a larger corporate structure, but we're talking about specific OD pairs here, and that has a dramatic impact on those individual origins if, in fact, rate structures impair their individual assets. So my answer is no.
And of course, I agree with that. You've been on the right track. Your decisions have found that the statute is aimed at the amount of traffic, not the size of the shipper. And I don't think we want to get to the point where we take a look at relative revenue between the railroad and the shipper, or net profits, and say that the one with the largest revenue loses. The railroads will lose a couple of cases to, win a couple of cases from big shippers, and under that measure should lose them all to everyone smaller than them. I don't think anyone is really talking about that.
Board is on the right track on this question.
I agree.
Vice Chairman Buttrey, any questions?
Let me just clarify, since this issue has come back up again. I was not necessarily suggesting this morning in my earlier comments that that's a direction that the board should take. We are very careful, I think, here on this level anyway, to not poison the well, if you will, with respect to any of those issues. I was thinking primarily about a situation where a customer was told or suggested to the customer that increase its 1 and 2 car spur line off and increase it to, say, a 20 car line in order to get better service or better prices or whatever, and then upon doing that got a 50% to 70% increase in rates just about the time they finished the 20 car spur line. So that's more of what I was talking about. Thank you.
Thanks, Mr. Buttrey. Commissioner Mulvey, any questions to this panel? Thank you. This panel is excused. Thank you for your patience and your testimony today and your answering the questions. What's your pleasure? We will invite the next panel forward. Panel number 3, representing Dow Chemical Company, Jeffrey O. Marino. Representing the Arkansas Electric Cooperative Corporation, Steve Sharp. Representing the Alliance for Rail Competition, Michael W. Snovich. And representing Snavely, King, Majoros, O'Connor, and Lee, Mr. Tom O'Connor. Welcome, and take your time to get settled, and we'll proceed. Welcome. We'll do our best to keep track of time the old-fashioned way. Excuse the technical difficulties. I don't believe the lights are still working, but I believe that the time allocations were 10 minutes for Mr. Marino and Mr. Sharp each, and also Mr. O'Connor, and 7 minutes for Mr. Snovich. I'll leave it to the panel. Do you have an arrangement already, or should we just start with our customary from my left to right? Rick?
I think that's fine with us.
Please proceed.
Good morning. I am here today on behalf of the Dow Chemical Company. Also here from Dow Chemical in the audience is Ted Verhagen, Dow's Legislative Counsel. Dow is pleased that the board has initiated this proceeding, but is concerned with the direction of the proposals, which would continue to leave shippers like Dow without regulatory rate protections. Dow is a so-called large shipper with small cases. Large segments of Dow's business involves transportation of traffic in small volumes to hundreds of destinations. Both the destinations and volumes had the potential to change frequently. Consequently, despite Dow's concerns over substantial rate increases on its traffic in recent years, the value of such rate cases does not begin to justify the time and expense of a full standalone cost presentation. Hence, Dow is among the captive shippers that Congress intended to protect through the small case process. This proceeding is very important to Dow. Dow has been among the chorus of shippers seeking revisions to and clarification of the three benchmark standard. Since the adoption of the three benchmark approach as the standard for all small cases in 1996, shippers have sought guidance as to numerous uncertainties about the timing, cost, and unspecified additional factors that the board might consider. Consequently, no shipper has been willing to test the waters by filing a complaint, at least not until very recently, as rates have increased substantially over and beyond prior levels. But in this proceeding, the board has proposed to go back to the drawing board by devising a new approach in the simplified SAC that is far more complex than the three benchmark, more costly, and more time-consuming. In your opening comments this morning, Vice Chairman Budry, you referred to the tax code and the simplifications being appearing more complex than even the original. And that's exactly what Dow thinks has occurred here. The simplified SAC is akin to the tax code that is more complex than the code is supposed to be simplifying. Furthermore, while the board has proposed revisions to the three benchmark approach in response to many of the longstanding concerns that have been raised, it has relegated that approach from being the small case standard to being the standard only for microscopic cases that are unlikely ever to be filed. The importance of this proceeding to Dow and other captive shippers has been further enhanced by last week's fuel surcharge decision in Ex Parte 661. Although that decision was a very positive step in protection of shippers, for captive shippers, those protections will be only as good as the rules adopted in this proceeding. Railroads can and they are treating the fuel surcharge as a zero-sum game by shifting the lost fuel surcharge revenue into their line haul rates. Unless this proceeding produces an effective and meaningful standard for small cases in order to determine the reasonableness of the line haul rate, the fuel surcharge decision will have been a hollow victory for captive shippers. Dow's primary focus in this proceeding has been on the eligibility thresholds because even the best substantive standard is meaningless if a shipper does not qualify to use it. The proposed thresholds in this case are far too low and thus deny rate protection to most captive shippers. Contrary to various railroad characterizations of shipper comments such as Dow's, Dow does not seek expanded regulation with guaranteed rate prescriptions. Dow seeks only a regulatory regime that extends protection to all captive shippers against monopoly pricing by market-dominant rail carriers as promised to those shippers by the statute. This means that no shipper should be left without adequate regulatory protection because the cost of invoking that protection far exceeds the value of their case. If that is what the railroads mean by an expansion of regulation, then it is a long overdue expansion that is mandated by the statute. Dow is concerned by the MVC approach because it overstates the actual value of the case, particularly for chemical shippers, where the RVCs on chemical traffic routinely exceed 300 and 400%. Thus, a prescribed rate is unlikely to ever approach the 180% jurisdictional threshold that is the basis for calculating the MVC. Based on the comments in this proceeding, Dow could support a variation of what the railroads have suggested in their reply comments, where the shipper is allowed to select its own MVC as long as it agrees to be capped by the rates in that. However, Dow's support for that approach is contingent upon having the information, including access to the unmasked waybill sample, to make an educated and informed estimate of what its MVC would be. Now, Dow also finds some merit in the board's recently suggested small claims approach, provided that the relief caps are set at levels comparable to the eligibility thresholds that shippers have advocated in this case. Currently, the eligibility thresholds proposed by the board are too low. They should be based upon a reasonable estimate of full SAC litigation costs multiplied by the risk factor of 3 that the interested parties suggested on the previous panel. The board's proposed $3.5 million eligibility threshold for full SAC is far too low because this amount is merely equal to what the board estimates the litigation cost of a full SAC case would be. Thus, an MVC of $3.5 million, while still significant of value to the shipper, it becomes worthless when the litigation costs consume most, if not all, of that value. Furthermore, the STB's litigation costs estimates exclude many costs that are true and important to the shipper, such as their cost of complying with discovery, their expenses associated with travel, and the lost management time in the distraction focused on a rate case. A risk multiplier of 3 applied to the litigation cost estimate is necessary to establish eligibility thresholds where the cost of a full SAC presentation is too costly given the value of the case. The aggregation rule also is an unnecessary restriction upon eligibility. Although based on the premise of gaming by shippers, there is no evidence to indicate that such gaming is or would become a problem. Shippers have ample disincentives to waging multiple litigations for what are speculative benefits. The rule also has perverse consequences unrelated to gaming because it would require consolidation of a single case of traffic from the same origin that moves in completely opposite directions. The rule also impacts situations that are not in fact gaming, such as when the second movement is not known or is not a concern at the time the shipper challenges the first movement. Any concerns about gaming by disaggregating cases can be monitored and addressed by this board on a case-by-case basis without adopting the broad and sweeping aggregation rule. Furthermore, the board needs to also be alert to the potential for gaming from carriers themselves. They have a lot of potential in where they set the tariff rate. Dow is not advocating any hard and fast rule against that gaming, but just as with the aggregation rule, the board should monitor the situation and be receptive to evidence that the railroads are in fact gaming the eligibility process. Dow supports retention of a modified 3 benchmark approach for all small cases. However, Dow rejects certain of the modifications proposed by the carriers, including the exclusion of contract traffic from comparable groups. A per se exclusion of contracts is unwarranted. There are increasingly fewer factors to distinguish contracts from tariffs. Contracts look more like tariffs. They typically incorporate tariffs. Issues such as volume commitments when you're a captive shipper really aren't a problem because you're going to commit all your volume to that railroad anyway. Service commitments in contracts are very rare nowadays, and to the extent they exist at all, they don't exceed the reasonable dispatch standard that applies to common carrier movements. Shippers also must have access to the unmasked waybill sample. Otherwise, the railroads will have an unfair advantage in selecting which traffic to advocate as comparable. There is no need to treat the waybill sample as comparable to the gold in Fort Knox. This data is the same type of data that's already produced in full SAC cases when the contracts themselves are produced to shippers. The same protective orders that protect that information in full SAC cases will protect it in small cases. Dow asked this board not to create unnecessary barriers to effective regulatory protection through the small case standards. Simplified SAC is an unnecessary sojourn into a quagmire of new uncertainties topped off by greater complexity, higher costs, and more time than the 3 benchmark approach. Attempting to adopt simplified SAC before giving the modified 3 benchmark approach a chance to work is unnecessary and undesirable. Shippers only recently have shown a willingness to use the 3 benchmark approach. Furthermore, the STB's proposed modifications in this proceeding will enhance the utility of that approach. Simplified SAC's greater cost, complexity, and time will create the same, if not greater, uncertainty that the 3 benchmark approach has taken 10 years to even begin to overcome. Please give the 3 benchmark approach a chance to work before turning the clock back on small cases. Railroad concerns with the 3 benchmark approach are red herring, overblown doomsday scenarios predicated on the notion of a deluge of 3 benchmark cases. There is no evidence that such a deluge will occur, and the railroads overestimate even the potential cases eligible for 3 benchmark because they have not considered that market dominance, contracts, and exemptions will limit the pool of regulated traffic. In summary, The board can monitor the impact of the three benchmark approach and the eligibility standards on both the shippers and railroads, and retain whatever flexibility they need to address any of the concerns that have been raised by the parties in this proceeding. At this point in time, however, where small cases have been without effective regulatory protections for over 25 years, the board should be tearing down barriers to small cases rather than erecting them on the basis of unfounded speculations. Thank you.
Thank you, Mr. Moreno. We'll now turn to Mr. Steve Sharp from the Arkansas Electric Cooperative Corporation. Welcome, Mr. Sharp.
Thank you. Good morning, Chairman Nottingham, Vice Chairman Buttrey, and Commissioner Mulvey. Appreciate the opportunity to speak to you all on these issues this morning. I am in charge of fuels and fuels transportation for Arkansas Electric Cooperative. Arkansas Electric Cooperative is a membership owned generation transmission cooperative that serves about 460,000 of our customer members in virtually every corner of the state of Arkansas. Our reliance on rail transportation and our interest in this proceeding were described in detail in our opening comments that have been filed that y'all have. In the interest of being brief, I'll summarize by saying that our primary focus is in looking at the simplified SAC procedure that has been proposed and its interface with the full SAC procedure that is used in the large rate cases. As far as from the shipper side of things, we may be kind of the Lone Ranger, I guess, in not having a great deal of protest about the simplified SAC proceeding. But our viewpoint is a little bit different perhaps than some of the other shippers, and we're viewing it as if we have the simplified SAC as an option that a shipper can avail themselves of. And of course, like I said, there's a lot of ifs and buts and details to be worked out. But if we had a simpler option than the full SAC, in addition to the three benchmark option, we think that would certainly be an improvement, and we compliment the board for considering that. I'll try to use the rest of my time allotted to address the issues that were highlighted by the board for this hearing. First of all, eligibility. We commend the board for its pursuit of the eligibility issues that have been raised. AECC believes that any eligibility scheme that leaves the railroad with influence over the selection of which of these methods might be used, simplified SAC versus full SAC, will tend to leave the railroad with most or all of the leverage that it holds from a shipper's perspective on full SAC litigation costs. Kind of what was alluded to before by Vice Chairman, this sort of leaves the railroads in the decider position, if you will. As we've discussed in detail in our written comments, this leverage enables the railroads to obtain revenues above those contemplated by the statutes and by the theory of constrained market pricing. This also keeps shippers from realizing the relief from full SAC litigation costs that would motivate us to have something like the simplified SAC in the first place. In our prior written examples, we've included ways in which a railroad might be able to set the initial rate in a manner that would ensure that it captures the shipper's full SAC litigation costs under both the board's original proposal and the railroad proposal that would have the shipper pre-specify a limit on the relief that it's seeking. The railroads are highly skilled at assessing the negotiating leverage of individual shippers, whether that leverage comes from commercial or regulatory considerations. If the board were to adopt eligibility criteria for simplified SAC that enables the railroads to put this full burden of SAC litigation costs back on the shippers, the railroads would do so. To ensure that simplified SAC actually provides shippers with relief from the full SAC litigation costs, the board needs to ensure that the influence or control over eligibility for simplified SAC is not held by the railroads. In looking at the new proposal that the board advanced on January 22nd, our first impression is that there's really not enough information there for us to know whether or not this will enable the simplified SAC to deliver meaningful relief from these litigation costs under full SAC. Due to this, we would support the testing that's been proposed by the DOT and has been mentioned by others today. We think that would be a good idea and would help us all be able to understand the differences between full SAC and simplified SAC better. If the board specifies a limit for eligibility as a fixed dollar amount, we believe the railroad would still apparently be able to set their rate so as to capture this leverage that I discussed earlier. However, if the board defines the limit with more flexibility, we believe this can be avoided. Specifically, we suggest that the board allow simplified SAC to be used without restriction whenever the relief in question does not justify the use of a full SAC methodology. Initially, this would entail application of our proposal that no limits on the use of simplified SAC be imposed where the combined full SAC litigation costs of the parties exceeds the amount in dispute. As more information becomes available, whether it's from testing or whether it's from experience over time with using a simplified SAC procedure, the magnitude of the disparity between the simplified SAC and the full SAC methodologies will be better understood. And at that time, the board should further apply this principle so that the incremental litigation costs of a full SAC are not incurred unless justified by the magnitude of the expected error that would be associated with the use of the simplified SAC. We believe it would be sound public policy for the board to use this approach to ensure that its rules do not necessitate wasteful expenditures on litigation. For shippers that elect to use simplified SAC above the limits established by litigation cost considerations, the board could limit relief by imposing whatever premium above the computed rate may be needed to account for prospective inaccuracies in the simplified SAC methodology. For example, in a large case where a shipper chose to use simplified SAC, the board could incorporate a premium above the computed rate to ensure that the prescribed rate was not improperly low due to inaccuracies caused by the use of simplified SAC. We believe any such premium would be small. The board has already noted that the simplified SAC procedure omits any possibility for future efficiency improvements relative to the defendant carrier's current actual operations. So like I said, there are a lot of unknowns. Testing might help verify some of these things, and as further information becomes available regarding the degree of correspondence between the simplified SAC method and the full SAC methodology, this premium concept could be modified accordingly. To facilitate this process, we endorse the comments of several parties to the effect that the board needs to test the performance of any new methodology like simplified SAC relative to full SAC. We were pleased to see that at least some of the railroad parties have embraced and sided our further proposal that the cost of litigating a rate dispute be shared equitably between the parties. Shippers who need to rely on the board's rate reasonableness procedures are already in a situation where they don't benefit from effective competition. So they face the prospect of paying rail rates that are much higher than those paid by their cohorts. At the same time, they have to expend substantial resources on litigation that other shippers do not, simply to establish a lawful rate level. Given that a rate case can also provide a railroad with information that is useful in its dealings with other customers, equity considerations clearly appear to support some degree of litigation cost sharing. Even with something as basic as the board's fee for processing a rate complaint, the board could require that some of that cost be shared. We believe such practices could help get both parties on the same page to agree on a rate that's consistent with the statutes with minimal unnecessary litigation. On the aggregation issue, or I guess we might call it the disaggregation issue, we believe that a shipper should be able to use any valid methodology on any portion of its traffic it wishes, of course subject to whatever limitations on relief the board may impose on these different methodologies. The board can, of course, retain discretion to consider this issue on a case-by-case basis. And also on the Simplified Sac Proposal, for reasons outlined in our written comments, we believe it's important that the board retain the option for a shipper to specify the route in Simplified Sac. Some of the railroad parties have tried to create the impression that the board could safely rely on the carrier to route traffic efficiently, and that any shipper specification of an alternative route would be suspect. When the railroad has enough market power that the shipper must rely on the board's rate reasonableness procedures, there are too many situations where use of this predominant actual route may legitimately be questioned. While we don't think this issue would come up in practice very often, the board should not get rid of the only protection a shipper has when it has a problem of this type. And again, appreciate the opportunity and be happy to answer questions when it's appropriate.
Thank you, Mr. Sharp. We'll now turn to Michael W. Snovich of the Alliance for Rail Competition. Welcome, Mr. Snovich. Please proceed.
Thank you. Good morning, Mr. Chairman and members of the board. My name is Michael Snovich, and I'm Executive Director of the Alliance for Rail Competition and a veteran of the shipping industry. ARC appreciates the opportunity to testify at this hearing. I have tried to avoid duplicating the points being made by the speakers representing the interested parties, since ARC joined in their comments and supports what those speakers are here to say. The subject of this hearing is most important facing the board, since it could provide an understandable, affordable, and effective way for the majority of American captive shippers to exercise their rights to challenge high railroad shipping rates as allowed by the Interstate Commerce Commission Act. The board has other responsibilities under the Act, but shippers have received little from the board in these areas. For example, the board has shown that it has very limited ability to deal with service problems. It can require reports from the board, that it has done in the past, but the board has said it is reluctant to overrule railroad management on service for fear that ordering better service to shipper A would result in worse service to shipper B. The board's very limited action in this area has been consistent with this reasoning. Another example is the board could promote rail competition, but it may have painted itself into a corner. The bottleneck and mid-tech decisions, various merger decisions, and numerous decisions approving line sales subject to paper barriers mean that whatever the board may do in the future may be a little too late. The board recently issued a decision modernizing its SAC procedures, but SAC is only relevant to a very small handful of shippers, and the recent rulings by the STB, as previous testimony has indicated, is questions whether filing has a chance of a shipper getting a reasonable rate. While ARC welcomes the board's rail cost of capital and grain transportation proceedings, no action has been proposed in those proceedings to date. And the board's action on the railroad's cost of capital is not the same as clarifying how revenue adequacy constraint of constrained market pricing will work. Therefore, the most important proceeding for the largest number of shippers is this one, as many have testified. If the board fails to do the right thing here, small and non-coal shippers will be defenseless whenever railroads charge too much. Naturally, this will make the railroads happy and make them richer. The railroads may even use some of their profits from captive shippers to expand capacity. ARC certainly doesn't oppose railroad investment or railroad profits. But there are right ways and wrong ways for the railroads to invest and to obtain a fair profit. Money extracted through differential pricing from captive shippers should not be used primarily to benefit non-captive shippers paying lower rates. This is particularly objectionable for revenue-adequate railroads that don't need more differential pricing. There are also right ways and wrong ways for railroads to set rates for captive shippers. First, they should maximize the revenue from other traffic, as the board has recognized. Second, No commodity or group of commodities should pay an unreasonable share. Third, no individual shipper should be singled out for excessive contribution. The board's three benchmark approach generally addresses these criteria directly, and ARC therefore favors it with some changes and minor clarification as described by the other witnesses. However, Simplified SAC is clearly an indirect, esoteric approach to these legal and common sense standards of rate reasonableness. As the other witnesses have stated, the Simplified SAC is more complex, more expensive, more demanding than the three benchmark approach. The railroads say it is superior, of course, since they know it will rarely be used and may produce no relief if it is used. Everyone knows that a full-blown SAC can't be used in a small and non-coal rate case unless it is simplified. The proposal on the Simplified SAC by the STB does not get us there. If small and non-coal shippers had an understandable, affordable means to challenge high rail rates, it will just mean they will no longer be at the railroad's mercy. This would create some bargaining leverage on the part of shippers that is sorely needed to offset the railroad's power. The railroads will and have claimed there will be a host of cases before the STB. This is nonsense. Any reasonable business person knows that litigation is only used as a last resort since the outcome is so uncertain, and I know that for a fact. Railroad progress towards railroad revenue adequacy will also survive adoption by the board of a simplified, expedited alternative to SAC. Capacity constraints are such on the railroads today that they are earning record revenues and profits with significant contributions from non-captive shippers. It is true that railroads will encounter greater resistance from captive shippers to very large rate increases, which is the way it should be. No customer in a free market simply accepts a huge increase without looking at other options, of which a captive shipper has none. In summary, the board's simplified version of SAC is expensive and complex. In ARC's view, this is contrary to the intent of Congress, which did not want captive shippers to be defenseless. It would be a grave mistake in the board's most important proceeding. I thank you for your time and attention.
Thank you, Mr. Snovich. We'll now turn to Mr. Tom O'Connor from Snavely King, George O'Connor, and Lee. Welcome. Please
Thank you,
proceed.
Chairman Nottingham. Good morning, Chairman Nottingham, Vice Chairman Buttery, and Commissioner Mulvey, staff. We're pleased to be here today, and I'm accompanied by Kim Hillenbrand, who is my co-author on this entire proceeding, the several appearances that we've made. We're going to address in these charts today many of the points that you asked for comment on January 22nd, and we'll give you additional comments in the February round as well. On the first chart here, the key to the solution to these problems that we've been talking about today is increased reliance, we believe, on marketplace strengths, marketplace dynamics. And we see an obvious opportunity to do more of that in increased access to and use of mediation. We're going to talk about more about that as this presentation goes on. The mediation options, however, have to be combined with litigation options, which pose a real alternative that both parties would be reluctant to embark on. If one of the parties, whichever party, sees litigation as a slam dunk, so to speak, for its side, it doesn't serve to motivate mediation. Mediation is really where the strength of this process lies. The adequate litigation options, we think, would implement the Staggers Rail Act long canon factors. We've heard a little bit about that today, and the record is quite thorough in development of those factors. Should address some sort of a remedy for captive shippers. That is the fundamental issue that needs to be addressed here. And it can be addressed at a number of different levels, and it's a global issue, if you will. On the one hand, and if we look at it microscopically or in a micro sense, if the railroads are in a captive shipper situation, it may appear to be that they have all of the power or most of the power. But if we step back a little bit and now consider the need to invest in railroad assets and consider the need expressed by many of the railroads for some sort of financing help on that in the form of tax credits or what have you, then the picture changes a bit. And the fairness that one is asking for in investment should be seeing that same kind of fairness and equity in the treatment of the captive shippers. But that particular problem remains to be solved. There's a lot of different ways to solve it. The Canadians solved it basically with a single word called interswitching. Has a dramatic effect, easy to do. In short, we have to learn from, I think, the experience of the past and do a little bit better to make sure that we have an effective and equitable litigation option that will energize the mediation alternative, which I believe is your real strength. And we'll talk to you a little bit today about some of the specifics. Let's go to the maximum value of the case just at the get-go. Here's what we're proposing here. To merge the small shipment and the medium shipment eligibility thresholds and increase them. We'll be back to you in February with what we think a reasonable number will be on that combined threshold. But I assure you it will not be less than $3.5 million. So therefore, you would have one threshold that would apply to both medium and small. Allow the complainant to choose which he's going to bring the case under. I predict that there will be a fair amount of cases brought over the years under the three benchmark method and the simplified SAC. I'd be surprised if you start a single case. We'll talk to you more about that. Now, we've been showing this particular graph here for the last 3 or 4 years. We've presented before you on a number of occasions, and we often use this graph. What this shows is if we had a $500,000 per year gain that was realized in a small shipment case, that is to say the rates were reduced by $500,000 or some gain of $500,000 per case. And then let's assume that we had 100 such cases. Now bear in mind we've had 2. We've been privileged enough to participate in both as has your staff, and I think quite well too. We have seen 2 in 10 years, but let's assume that there were 100 such cases in a single year. All of them, each and every one of them, realizing a $500,000 gain. That would amount to 1/10 of 1% of the rail revenue. 1/10 of 1% of the rail revenue. Absolutely no threat to revenue adequacy. Now that 1/10 of 1% is the figure we calculate with the 50 million. 50 million is what we would get out of 500,000 times 100 cases. That's what we calculate using the 2002 waybill data, $40 billion in that number, 1/10 of 1%. 2005, it's up to $46 billion, still 1/10 of 1%. There's a little bit, we're on the second or third decimal before we begin to pick up any difference there, 1/10 of 1%. Also, there's kind of an implied comment on whether ratcheting has occurred. One would predict not. Let's move on to the next slide. Simplified Sac Proposal. As I say again, the limits on the maximum value of the case for small and medium, we recommend combining them into a single threshold. Increasing that threshold, we'll be back to you in February with what we see as a reasonable amount to set that threshold at, and then let the shipper decide whether they bring it on 3 benchmark or bring it on simplified SAC. Now, as I'm looking at simplified SAC, it seems to me that it's not going anywhere. Its predicted path, and there's a little bit of history here. We've heard a little bit about it, the mid-90s attempt by the AAR that resulted in it was quoted this morning as 5,000% revenue cost ratio, but as memory serves me correctly, and I was not involved directly in that proceeding, but I want to say it was more like a 4,600% revenue cost ratio, not quite 5,000. But what was going on there was reductio ad absurdum. A method that could produce that kind of a result and have that result be deemed as adequate, it basically disposed of the method. So again, we want to take a good look at testing before we go too far down the line with simplified SAC. But the predictable path of development, which is what we're talking about on the bottom bullet, is very easy to see. And Nick had some comments on this, and other people have commented on already. There's an almost automatic tendency of the parties to get the data in the analytic techniques more complicated, more thorough, more precise, more micro, and you're moving in the direction of SAC. So the resting point of simplified SAC is SAC. So if you cannot solve your problem now with SAC, with a little bit of development of simplified SAC and the natural migration of it in the direction of SAC, you'll arrive at the same point. You'll have a complex process that basically meets few needs. So and there again, the problem goes away if you let the shipper choose. Let the complainant choose. I rather suspect there'll be very little choice for the simplified SAC. Litigation costs. This is a point of clarification. We won't dwell on it. A couple of places in the record, we are on the record as $50,000 consulting and legal fee. Think of that as a minimum. We have a little bit of experience in this, and it's safe to say that the $50,000, that's I believe the way that we said it, is the absolute minimum that you could do this on a good day with everything going in your favor. Now, you can very easily get to $100,000 and above. Now we're talking small shipment. Now, think of it as a cost minimum, not an average cost, definitely not a cost maximum, should not be used in either of those senses. The fact of the matter is that we had extensive experience working on behalf of both of those clients on whom we brought the small shipment cases. We knew their data very, very well. We knew their operation very, very well. So there wasn't much of a learning curve there. And we designed the cases to be solved in mediation, and that is the way the first case went to completion, successfully in mediation. And I'm hopeful that the second case will go to completion, successfully in mediation today. Other issues. Aggregation. This is an easy one. The aggregation, I really recommend that you eliminate it. And in your January 22nd decision, if you will, you allow the opportunity to reinstall it if it becomes an issue. It's really just directed at abuse. And if you do not have abuse, then that should never come back up again. If you have abuse, you can deal with it very, very quickly. But if we have aggregation as a broad feature of the process, you're eliminating benefits that you could be providing. You could be solving problems for both the railroads and the shippers. So I would recommend dropping aggregation and return to it if as and when it becomes an issue. Routing of issue traffic, not a problem. I would definitely allow that. We've done a fair amount of network analysis of railroads over the years, and compared to the complexity of the proposed SAC methods, simplified SAC methods, the routing alternatives are fairly straightforward. The problem that you run into is the need to cost on and off the standalone rail network. That's where the real problem is. And if we go back to an attempt that we made in another proceeding back in the 1980s, I can assure you it can be done, but it is definitely not simple. And there is a great deal of opportunity for mistakes there. Ratcheting, we don't see that as a problem. Access to the unmasked waybill sample, we see that as essential for both parties. The RSAM, the new method, we believe is better because it is more transparent and it includes all railroad traffic. When you are including all railroad traffic, an awful lot of problems go away. We don't have to worry about getting an upward bias by confining our traffic that we're looking to for guidance, if you will, in the sense of a comparable RCR to that which is above 180%. Include all the traffic almost as like an axiomatic approach. And the same point on non-defendant traffic. Include all of the traffic. Mediation. This is what we believe if you provide increased access to mediation, you will benefit all parties and you will benefit this agency. You will succeed, and so will the parties. And the reason is that it allows the parties to come together and produce a market solution, working together collaboratively and creatively. And that's exactly what has happened in both of the cases that we have brought. Working with your senior staff in this fashion. This works. This works very well. The Moreover, it provides timely resolution. There is the number 20 days in the January 22nd piece. I would definitely recommend 30 days. And as I said earlier, Kim and I have a letter that would wrap up the second case today if we get the call from the client that the last little detail has been resolved. Otherwise, we'll probably ask for another week or two because we are that close. We're that close. But you do need some time. I would say 30 days would be an adequate time. And as a matter of fact, I would think too that most of the energy, most of that time period, in fact, is going to be used in translating the agreement into a contract. It will not take long for people pulling together to reach terms of agreement that will be appealing to both. It takes a little bit longer to get it translated into a contract. So, additional benefits from mediation is an economical alternative to litigation. Now, bear in mind, my low numbers contrasted with everybody else's high numbers. My low numbers are kind of based on a mediation approach to life, if you will. 3 days, not 3 months, just 3 days. It provides confidentiality. That's part of the key to releasing that creative energy. Work together and not worry about whether you're going to have to face what you're proposing as a solution today in some adverse way downstream. And it's clearly win-win. Frankly, we see virtually no downside to it. Very, very effective, and we have used mediation here at the board. We have used mediation elsewhere around the U.S., and it is my preferred method. We've used arbitration as well. I prefer mediation to arbitration. Now, in summary, we recommend rail rate reasonableness review based on the STB 3 benchmark guidelines. I would recommend let your customers choose as to whether they want simplified SAC or the 3 benchmark guidelines. I would predict virtually nobody will choose simplified SAC. Now, when you're leading people in the direction of mediation, there's something else occurring too. I think that the constrained market pricing and standalone cost has met some needs. Clearly, it's met some needs, and it's morphed over the years, the last 20 years. That is a simulation of a hypothetical market. Mediation is the ability, it provides you the ability to produce an actual market solution. You get the same strength without confining it to a Byzantine set of rules. At any rate, as you have concluded by now, I'm quite a fan of mediation, and I recommend it highly to you. We've successfully used all of the techniques we recommended in this presentation, either here or in other mediation forums, and I can assure you they work. Thank you very much.
Thank you, Mr. O'Connor. And glad to hear the good news that there may be a second successful mediation concluded as early as today.
That's my hope.
Congratulations, and thank you for sharing that with us. I think aspects of your testimony were so important because it's a little told story. They're actually, if I heard you correctly, don't let me put, please, words in your mouth, but can I restate what you said basically is you've worked on 2 successful mediations. The costs without, range could be as low as $50,000, but, maybe $100,000, but not that much higher, if I heard you say. I mean, it's...
Yeah, and what I'll do, Chairman Nottingham, is I will get the clearance from my clients to...
And please, I didn't mean to intrude on...
To put a better number in, but the $50,000, if I were to start today, new case, but give me a case where it's a client that I've worked on over the years, and there are a number of those, we are definitely going to be saying to that client that we can do this for less than $100,000. We're definitely going to be under $100,000, provided we can get it done in mediation and do not have to go over into the litigation phase.
Well, I think that's a message well worth hearing. We often do hear talk, at least that it's just impossible to get justice, so to speak, before the board for anything less than many millions of dollars. And I think you at least have a story that's very well worth hearing, and thank you for sharing that with us. Let me ask, in your mediation experience, how important was it, because I think I know the answer to this, but I haven't personally gone through a mediation of this type. How important is it that all the parties come to the mediation really ready to give mediation a chance?
Very important.
Sometimes we hear that it's not always the case. It's the litigation team has taken over, briefed their client on the 4-year ordeal they're about to go off on, and they're just want to get mediation behind them and are looking at the clock, so to speak, instead of across the table in good faith.
Thank you very much for pointing that out, Chairman Nottingham. And that is a problem if and only if one of the parties really is just kind of taking a brief detour on its way to litigation. But what we're suggesting here is that the litigation option should be sort of equally unappealing to both. And let's get them focused in the room on, we can do the solution right here. There are 3 people in the room today. Rachel behind you is one, Kim is one, I'm the third, who have first-hand experience with the first mediation, and it concluded successfully, I believe. I think all parties would agree on that, and I expect the same kind of an outcome on the second one. With a completely different cast of characters. I mean, only Kim and I are the only 2 common ingredients in that.
Thank you. Mr. Snovich, if I could ask, one of your comments especially caught my attention about, if I heard you correctly, that you said something to the effect that differential pricing or rail revenues derived from differential pricing should only be invested to the, and I'm paraphrasing here, but to the direct benefit of the captive shippers who are paying those differential prices?
No, I'm not. It's saying that some of it should go to the captive shippers. Not all of it should go to some of the other shippers that aren't captive. In no way, shape, or form am I indicating all of it goes to captive shippers.
And this is all, of course, in the context, if I've heard you correctly, of looking at investments that railroads say they need to make.
Correct.
Maintenance capital.
Right. You must have also contribute some of it towards the captive shippers, not only the shippers that aren't captive. For example, intermodal.
How would that? How would we work through that in the real world? For example, a project that I've had a chance to personally visit, and we're probably all familiar somewhat with at least, is like the Chicago Create project, one of the world's foremost traffic congestion points that causes increased costs and time and money for everybody, shippers, railroads, and is there, and maybe that's not the right example, but could you imagine a scenario where a captive shipper wouldn't benefit from solving the Create mess, just for example?
I'm not indicating that that's some money that shouldn't be spent on that project. Definitely captive shippers would benefit somewhat from that project. But you shouldn't just worry about, for example, a project that maybe services the intermodal traffic, which is really a competitive type of traffic.
So let's say the port of L.A. Long Beach happens to be the nation's busiest intermodal port, and it's fair to assume that a major reason that railroads are interested in investing in improved capacity in and around that port is to facilitate intermodal, but maybe perhaps not the only reason. Presumably there is a big variety of traffic that goes through a busy port like that. How would we, I'm trying to sense how we would work through that, because it's the most extreme, I guess, interpretation of your remarks would be if a captive shipper can't actually see the work crew from his property line, then it ain't benefiting him. And the other extreme would be if it's in no way, shape, or form could any reasonable hypothetical be developed that would show how the network on which that shipper depends would be benefited. So there's these extremes. I'm trying to get a sense how we would work through that.
The worst scenario is that the board is responsible for dictating exactly where the money is spent by the railroads, just because it's differential pricing money versus or captive shipper money versus non-captive shipper money. But the real situation here is, I think captive shippers, if they feel they have opportunity to get fair rates, a way to get them, and especially the small captive shippers that we're talking about today, wouldn't be as concerned about where the money is spent, providing they feel they have access to fair and equitable rates. They have a process in place, simplified, not very costly, very quick to complete. That's the key. But when they see they feel they're being exploited with very high rates, and then on the other hand, they're not getting good service. And I testified at a hearing just recently by the grain shippers on talking about service, and the issue was a lot of that revolved around and they're one of the parties out there that see themselves as being high rates, and they get inadequate service. These are the ones that they say it's unfair. Now, if you solve the problem of rates, some of these other issues may go away.
Thank you. Let me just yield to Vice Chairman Buttry for questions.
I was just going to ask Mr. O'Connor how he feels about Canadian-style arbitration.
Well, I haven't arbitrated in Canada. I have testified in Canada, and the Canadian situation has a number of differences between Canada and the U.S. One of the most important differences is the availability of interswitching. Where if we are within, I believe it's 30 kilometers of another option, you can request and receive, if it gets that far along in the process, you can request and receive a competing bid. Let's say, and typically we're talking CN versus CP here. Now, I think there have been very, very few cases, if any, where it got all the way to receiving a competing rate that actually was moving traffic. But the very presence of a possible alternative alters the situation. And when we bring additional alternatives to the transaction, everybody's thinking differently. Everybody thinks differently. It is the natural inclination of folks to want to capture all of the gains available for their side. And if they believe that you do not have an alternative, their conception of those gains will be vastly greater than if they believe you have an alternative. So, in that regard, I would say there are some aspects of what's going on in Canada that I think are beneficial here. It's been my experience over the years that we are typically leading Canada, if you will. In other words, what we're doing now, Canada may be doing 5 years hence. But in this one respect, I think they're leading us. And I see the possible benefits of using that are immense. And it solves a problem which, if unsolved, will continue to percolate. Legislative remedy that people were talking about 3 years ago, 2 years ago, 1 year ago, those legislative remedies begin to gather steam over time. I think the two pieces of legislation on the Hill, one of which would remove the antitrust exemption of the railroads, was a non-starter. I think it had one sponsor, I don't even know who it was, for like a year or two. Now, last time I looked at it, it had 9 sponsors. And the more moderate legislation that would require us, by you, to take account of the presence or absence of competition in your rate reasonableness, that's all I'm suggesting here. That has, I think the last time I looked there, it has about 27 odd sponsors. That one's getting close to having enough mass to become legislation. But it doesn't have to happen. You could solve it right now. You could take the impetus away from that bill right now.
Thank you for asking the question about pending legislation, Vice Chairman Buttry. Thank you for your time.
You're close enough to it.
I didn't say that, he did.
I could see it from there.
Commissioner Mulder.
It sounds as though you're extending the reciprocal switching up in Canada as a new form of contestability theory, that you don't really need to have the service, just a threat of service can bring people to their to mediation and to resolution. We have mediation here in the STB, of course, for all of our large rate cases. We start out with a mediation period. That has never resolved anything, although it has been successful, I guess, in resolving some issues before we go to full litigation. But in terms of getting an actual complete resolution, that hasn't happened. Both parties figured that, I guess, they could do better if they go before the full SAC. And those are the large cases where the amounts involved are fairly high. Let me ask the group to comment on the exclusion of contract traffic from the for putting together the comparable groups. It's been suggested that the contract traffic is just too different. I know you addressed it, but would other members want to address that, whether that contract traffic should be included in the development of the comparable groups? Tom?
I'm ready to, I'll defer, then I'll have comments on it.
I go along with the testimony of interested parties.
I think it should be included, no question about it. Yeah, no question.
So you don't think it's sufficiently different from the tariff traffic that, and is that because of the changes that have occurred over the last 10 years in the market for railroad services, or do you think that's naturally the case, that there wouldn't be significant differences?
Actually, both. I think that whenever we have 70–80% of the universe, if you will, in a given category, then to exclude that category, we really run the risk of veering away from a good measure of the norm. And it's beyond question that that contracting, which initially kind of got started slowly, then it has gained momentum since Staggers was passed in 1980, and now it is. Has been, with a few exceptions that have popped up in the last couple of years, it has been the norm for how railroads prefer to handle the traffic, and most shippers, I think, prefer to have it too.
Although the length of the contracts have been shortening lately as they've come due.
That's correct. Yeah.
One of the reasons why I think why the staff developed the, if you like, the simplified standalone cost concept is in part because this is what the standalone cost concept itself has withstood court review. As you know, the court has tried other approaches in the past and they were struck down by the courts. And one presumes that simplified standalone cost is a little closer, would normally give you an outcome closer to the full standalone cost CMP approach than with the three benchmark approach. Given that, don't you think that some shippers will choose the SSAC approach if indeed you would make the difference in the caps on recovery sufficiently different so that there will be an incentive to choose it to the SSAC?
I think if you've made the differences on the caps really dramatic, so that, for example, you had the sort of cap that we're talking about in small, and I don't think anybody really believes that that's a legitimate entry in the race here, but 200,000 is so small as to be to reductio ad absurdum here. But if we had very, very tiny availability of eligibility, if you will, on the small, very high eligibility on the simplified SAC, you'd almost push some of your market in that direction. But I think more of your market would just go away. Mm-hmm. Some of your market would still come to you in an attempt to produce a workable result in mediation.
Well, the 10.5 and 13.5 thresholds that were talked about by the previous panel is probably too narrow a threshold to get anybody to choose a simplified SAC. Mm-hmm. So if you want to say from 10.5 to say 21 or 25, right, you might have more of an incentive to go for the simplified SAC approach.
Right. I can see simplified SAC requiring that sort of a reward incentive. Mm-hmm. And almost it's a case too that you have to be geared up for it. Simplified SAC, I would say, is akin to war. I mean, SAC is akin to war. There are no prisoners in that game. Whereas mediation is akin to a conversation among people working together. It's a different kind of a market.
Okay, thank you. Thank you, Mr. Mulder. Mr. Moreno, did you touch on the issue of contracts sometimes being resembling tariffs? Could you expand on that, what you meant in saying that?
There are several perspectives to that. One is contracts in large part simply incorporate the tariffs by reference, and increasingly the contracts are getting shorter and relying more upon the incorporation of the tariff terms. And even if they're not incorporating the tariffs, they are simply restating what the common carrier obligations would be if you were moving under a tariff rate. The contracts are also getting shorter duration, which is allowing the railroads to change their rates upward almost as quickly as they do with tariffs.
Thank you. And please don't take this question to be an effort to pry into anything that's confidential or strategic in the sense of business. But is there, and I may ask Mr. O'Connor or anyone else to weigh in on this, there is, of course, from the board's perspective, at least one very meaningful difference between a tariff and a contract, which is that one we have jurisdiction over and the other we don't. Is that a consideration very often when you're talking about packaging up a tariff into a contract and then deciding how you label that page? As you use the C word or the T word, or is that even an issue in today's market?
I don't think it has been in the past. As more contracts are coming up for renewal, it's not becoming an issue simply because the railroads are refusing to enter into contracts and moving over to tariffs. In the chemical industry, they are still entering into some contracts, but as I said, those contracts are changing in form, duration, to more closely resemble tariffs.
Okay. Mr. O'Connor, any experience in this regard? If we were to try to, I realize I may be departing from the specific topic today, but it was raised and it got me thinking a little bit. I mean, should the board look for something meaningfully distinct between a contract and a tariff? Or are they all just the same, just different words used?
They're quite different, actually. And what you see up until the last couple of years, as Jeff just indicated, is a pretty strong preference for contract on the part of both shipper and railroad. And I guess you'd have to ask the railroad members, and we're going to talk about this afternoon, why they are less inclined to contract these days than they were earlier on. But there is a certainty that's available in the contract that's quite appealing, and it is more or less totally absent in the tariff. And the fact that your rates could change within 20 days notice or less is a real problem. And it's kind of an unusual example, but I had one instance in the last year or two where the rates changed kind of after the fact. It was kind of a procedural accounting type thing. The only problem was that the material had already been delivered, and it was in a building owned by somebody else. And at that point, the rate went up on the freight. And one option would have been to get the building disassembled and backward started, but that wasn't terribly appealing. So having a kind of the ability to have short-term changes in the prices doesn't often get you to that kind of a situation, but it's something to think about, especially if you're bidding a long job.
Chairman Nottingham, if I may supplement my additional response, I think one thing that would help you understand the relationship is how contracts, particularly in the chemical industry, are structured. They're often entered into master agreements that may last for many years, but the rates themselves are set in lane agreements that are subsets of these master agreements. And these lane agreements are added as necessary as new lanes arise, and typically may have a duration. The rate may have a duration of 1 year, subject to renewal or cancellation on 30 days' notice. So in that form, the rate, these lane agreements are often very closely resemble tariff.
I agree.
Thank you. Mr. Shaw, you had mentioned that we should be watchful for or concerned about the potential for railroads to actually influence the size of the case, shape the size, if I heard you correctly. Help me think through how that would happen. I just want to make sure I understood what you meant.
Yes, what I was referring to was the example, and we've got an example that we gave in our prior written comments, where the railroad can influence, if we have this hypothetical situation that we've set up here with simplified SAC being available versus full SAC, that the railroad's rates that they choose initially, once it's known what the SAC and the simplified SAC conditions are that would be imposed by the board. It might be possible for a railroad to prescribe an initial rate that they know would push you away from getting any savings out of the simplified SAC.
Okay.
So in that sense, as I said, it kind of puts them in the position of the decidor as to which methodology would wind up being used.
Okay. Vice Chairman Buttrey, any questions? Commissioner Mulvey, any questions for this panel?
I just wanted to ask you, Steve, didn't we address that point that you raised right now in the six changes we made to the full SAC process, just to try to get us so the railroads can't game the system by coming in with an excessive high rate? I thought that was one of the things we addressed in ex parte 657.
I think there were some things in 657 that helped that, but in terms of looking at this, like I said, what is now a hypothetical situation where we would have simplified SAC versus full SAC, and the different options that we're looking at right now, I think there's still a possibility. There again, depending on the details that the board decides on ultimately. And I guess our main thing would just be to reinforce that we don't think it should be left that way. We think the determination of which of these methods to use should be completely in the hands of the complainant or the shipper.
And that's what we propose in our January 22nd decision.
Right.
Thank you.
Mr. Sharp, just one more question, if I could. Thank you for your patience. You described a concept or a recommendation, if I heard you correctly, or a proposal that we set no limits on a shipper's ability to avail him or herself of the simplified SAC process in cases where the cost of bringing such a case, if I heard you correctly, would exceed the actual award or damages. Help me understand. Is that I want to make sure I understood how you described that, because I just want to think through how that would play out and whether we would then need to be, as a board, looking at litigation costs to make sure that's it is as it's being purported. And I'm not sure, it's a whole other area of work that we just want to make sure we fully appreciate before we venture too far down that way.
Sure. What I was saying was, and what we recommend is that there not be any limits placed on the use of the simplified SAC by a shipper where the combined full SAC litigation costs do exceed the amount of the dispute.
Okay. So there, to play that out in a real hypothetical or a hypothetical, if we use the $3.5 million benchmark just for discussion purposes, and a shipper incurred costs of $5 million bringing a case, but only had $3 million or $3.4 million of actual damages, they would avail themselves of the.
Well, we're just saying in that situation that they're, that the board shouldn't put any limits on the shipper's ability to choose the simplified SAC.
Okay.
I mean, once you're in that situation where the benefits are not as great as what the full litigation cost is, we think the board should make simplified SAC available to the shipper without any other limitation.
And how would we know what the full litigation costs are? It would be something the parties would basically educate us on?
There's been a lot of discussion about that today. I mean, that's one of the things that we've all been commenting on, and that's yet to be determined.
Okay. So it could be sort of on an average in cases, not just particularly necessarily on one case or a case. It could be some finding that on average it costs a range, and we've heard some testimony today, but where are you indicating that it would be actually, here's our law firm and consultants bill, take a look at it, STB, and,
No, I would say it's more, as you described, that there's some preconceived number or notion at least as to what these costs are, and that in the determination of, in these eligibility determinations, that gets taken into account.
Thank you. Any other questions for this panel? Thank you very much. This panel is dismissed. We appreciate your time and your testimony. We will call up our next panel, which is a panel of one. Mr. Gordon P. McDougall from the United Transportation Union General Committee of Adjustment, who has requested 3 minutes, and we welcome